Good morning and welcome to Sorainen's Baltic Competition Law webinar. My name is Kaupo Lepasep. I am Competition and Regulatory Partner in Sorainen, Estonia, and today I am your moderator for the event. Sorainen started with webinars to our clients when the coronavirus landed in the Baltics, and our clients were thirsty for new information, but traditional seminars were not an option because of the lockdown rules. Now we are gradually phasing out Corona-themed seminars and hope to leave these topics to the history. But what we have learned was that webinars give a nice way to provide also very specialized seminars, bringing together specialists and interested people across the different countries to discuss very specific topics. And today's Baltic Competition Law webinar is one of the early birds in the hopefully long line of dedicated specialized webinars that we are going to offer to our clients and also to our wider community. And interest is there. We have 170 people registered to this event. Welcome, everybody. Like other webinars, after the event, this webinar will be available from YouTube and Spotify from Sorainen's channels. So you can tune in to the best pieces also after the webinar. We really appreciate your help in making this and other webinars better and improving them for the future. First, after the event, please give us feedback. What you liked, hopefully there will be some that you will like, and where would you like to see improvements. And during the event, you're very welcome to ask questions. On the right side of the screen, you will have a Q&A box. Type your questions there. Ask many questions, ask intriguing questions, and ask provocative questions. This way, you will help us to offer you the most interesting event possible. We try to respond to all questions, either in the chat or in the special Q&A session. But if some questions are missed, and these are very, very important for you, then please contact Sorainen speakers after the event. Regarding the questions, one warning. We may not be able to discuss ongoing cases or questions which are very case specific. Because after all, this webinar is for learning, discussion and exchange of ideas, but we really should not interfere with due process and due investigations. And now let's get to the agenda of today's event. During the next 1.5 hours, we will handle two topics. First, whether and which impact coronavirus had to the competition law enforcement in the Baltic countries. Does it really mean that now the world has completely changed? The competition law as we know it doesn't exist, or shall it continue as business as usual? In the second topic, we will discuss the rather controversial topic of the ECN Plus directive and its implementation. Are we really going to depart from due process and rule of law in competition law enforcement, or are we finally handling minimum necessary tools for our authorities for efficient competition law enforcement? And today's speakers helping us to get these questions answered are in front of you. Okay. I'm glad to say warm welcome to representatives of all three Baltic competition authorities. Šarūnas Keserauskas from Lithuania, Jānis Rako from Latvia, and Juhan Põldros from Estonia. And they are accompanied by some of the brightest minds in the Baltic competition law. Eva, Marika, Monika, and Pive from Sorainen. And hopefully you're going to like the entertainment we are going to offer you for the next hour and a half. And please ask questions. Now, Monika, what is the first topic you are going to offer to us today?
Thank you very much, Kaupo, for the introduction. And the first topic and the first discussion is related to the procedural aspects of the work done by the competition authorities in the Baltics. We have seen that the COVID-19 has changed the lives of individuals. It has changed the lives of businesses. We have also seen some implications that it has changed the work of the European Commission and certainly should have affected the work done by the Baltic competition authorities. We have seen some warnings, public warnings, but that some of the procedures might take longer than usual due to the pandemic crisis and the lockdown. We have also seen that due to the quarantine, the authorities had limited possibilities to perform dawn raids. And the purpose of this discussion, the first discussion today, is to hear from the representatives of three Baltic competition authorities. How has the pandemic affected the work and the procedures of the competition authorities in the Baltics, and what could be expected in the future? I have prepared several questions, and I would like to kindly ask all three representatives from the Baltic competition authorities to comment on those. And if you don't mind, I would like to suggest to start from the representative of the Lithuanian Competition Council, Mr. Šarūnas Kasarauskas, then followed by representative of the Latvian authority, Mr. Jānis Račko, and finalizing by the Estonian representative, Juhan Poldros. So the first question to all three representatives is the following. Could you please comment how the pandemic has affected the priorities of the competition authorities, and have you noticed any particular trends or business sectors that would require greater attention?
Thank you, Monica, and good morning, everyone. Good afternoon, whenever you're watching this webinar. It's been a topic that we've discussed on several occasions already. COVID-19 and competition enforcement. You know, perhaps I would surprise or maybe not surprise many people by saying that it has not affected a lot the way we work. If only because we already had flexible work, flexible hours, and most of our people have portable computers and can have safe access to files from home. So when COVID-19 came and the quarantine measures were adopted, we just continued to work mostly from home. And on that front, we have not noticed much of a change. Well, of course, we lacked the social aspect of work, but other than that, the work continued. Has it changed our enforcement priorities? No, because we have always said that competition for the benefit of consumers as the final beneficiaries of this process is our priority, and it continues to be regardless of the COVID-19. What has changed? It's the facts on the ground, as they say. And in response to those facts, of course, we have to adapt our actions, both advocacy actions and enforcement actions. So we have seen in some businesses some measures taken collectively by competitors that drew our attention, and we reacted one way or another. We started some investigations. We issued warning letters or took other advocacy measures in relation to other actions. So there was some movement on the business side. And of course, we, as part of the European Competition Network, we issued a joint statement saying that, in a nutshell, all the initiatives taken by the businesses collectively, if they are beneficial to consumers, they will be supported by us. Then again, is that a great change? Well, no, because that's always been the law, that agreements even between competitors, if they benefit consumers, they can be allowed. So in many ways, we have not changed that much, but I think there are some lessons that we'll take and adopt in the future. The way we organize our work. For example, yesterday we carried our first public hearing online. with almost 30 parties present, and I think that went very well. And I think that we will consider having these online hearings in the future, regardless of the pandemic, because they might be just convenient, not for ourselves, because we'll be probably in the office, but for example, business representatives that live far away from the capital. And the other thing that we discovered, that working from home can be quite effective for some people, not for others. So we'll become even more flexible. The last thing I wanted to mention, perhaps when it comes to COVID-19 and our work, is the merger work. Unlike some authorities, we have not encouraged parties not to file. We just issued a statement saying that the parties should expect and should consider that some things may take a bit longer, like information collection, because for obvious reasons. And we carried our work without great trouble so far. So that's on the Lithuanian side. Perhaps we have not seen everything yet. Perhaps there will be some cases in the future that will have a COVID-19 aspect. But as things stand now, we're in good shape.
Thank you. If Yanis, you could comment on the question how the pandemic has affected the priorities, and have you identified any sectors and also the procedures?
Okay, thank you for the invitation. Hello to everyone. Morning. Talking about how it affected our work, I fully agree with Sharunas. Yes. Of course, at the starting, when the emergency situation started, we needed to shift and adapt to new work conditions. It took a little bit time, but anyway, what we discovered at the end, it's more easier and more comfortable way to work, and more flexible way to work remotely, and offer such also possibilities also for undertakings to meet through such not webinars but meetings in online, and what we didn't use previously so often, maybe we will consider in the future to use it more often. It's of course reduces resources and adapts also how we possibilities, easier to get information, to explain maybe questions we ask to the market participants and to the undertakings. That is how we adapted to this work, and we see that is a good learning, a good experience. Talking about the priorities, I think it's nothing much change in respect of cartels. Abuse of dominance is still regarded or seen as the most serious infringements. If we talk about some sectors which is maybe to the restrictions to the applied to the government, also in the sectors which were affected by the COVID-19 in different ways. In this case, of course, any information exchange make us worry, and we recommend undertakings to consult with us in these cases to provide information, what such information exchange, in which form it will be shaped, what information will we exchange, and what are the objective reasons. Because in this case, the difference between usual situation what was previous is some objective reasons or facts that affected the undertakings and that justifies such cooperations in these cases. As you may know, we issued a comfort letter, say about procedural setup. Yes, during the COVID, we maybe adapted and most fast and reacted on such requests of to supply our opinion on certain cases, and it was one of these situation agreement was between the banks. Moratorium, the banks agreed not to prolong the basic sum repayment for the clients. Of course, this was as a recommendation. It came as a recommendation request from the regulators. This is an additional reason, but anyway, what we focused on, and maybe it's talking a second topic, but anyways, we focused on information exchange risks and risks for exclusion of other banks from such agreement. Of course, that is maybe difference between how we reacted in this situation. We tried to react more faster if there are such and evaluate the information provided to us. Of course, we request more, let's say, wide information and testify that this all information is given to us about any cooperation. That means in ordinary cases we could react more later or evaluating more carefully and switching the priorities to other cases. In these situations we reacted more faster and devoting resources to such evaluation. Of course, the result doesn't mean that such agreements are allowed. We only provide an opinion that such agreements are in this case, and due to the information provided to us, do not pose the risks, and it is not a matter of investigation now. Talking about procedural aspects, did it affect downgrades? I think not. It's from a legal side. If we talk about mention this, of course there is some tactical things you can use and we can assess. I will not share these, but which may affect in certain situations how we conduct investigations due to the restrictions applied to the market participants and businesses working remotely. But anyway, from a legal point of view, I don't see the restrictions to use our investigation powers. Of course, we need to use it proportionally and taking into account situation objective facts. Of course, talking about mergers, yes, we trying to, but we see it's yes, merger filings and notified mergers are declining during the period. What we expect in the future maybe will be a rise of such kind of mergers as failing firm acquisitions. Maybe we will see due to the consequences created by the COVID-19. Yes, in one case we also prolonged. We have the maximum time for the investigation of merger 4 months. In one case, due to the objective reasons, we also prolonged this term beyond that. But we carefully assessed the reasons why the undertaking, which we requested to supply information, was not able to supply information in certain terms. And due to that, we saw that we need to prolong also investigation period in this merger. That about mergers. I think about procedural aspects, deadlines. Yes, it's a merger cases. In one case, we prolonged the deadline, and other procedural aspects, I don't see problems. We are trying to. We are asking still. Yes. Information, of course, it's up to other undertakings inform us about the procedural reasons, about the reasons, objective reasons, but they are not able to provide this information to aggregate and etc. Yes, it was. We didn't try yet the public consultations, or not the public consultations. We are not providing public consultations or hearings. But anyway, we didn't use such online hearings now, but maybe we'll try later. Of course, it could be a good way to do it more effectively.
Thank you very much.
Thank you.
Yanis. And could I please ask also Mr. Juhan Poldros to comment what the pandemic has changed and what could be expected in the future?
Thank you very much. And first of all, let me thank Sorainen for arranging this event. And it has been also for me quite interesting to hear the experience of the colleagues from other countries. But speaking about the effects of the pandemic, it seems to be pretty much the same way as in our neighbors, that it hasn't had any drastic effect on the way we operate daily. When it started, then of course there was this feeling that this is going to change the world, and the competition law, like many other fields, is not going to be the same anymore. But indeed, looking back at the time, we didn't see much situations where you can see that this is a competition issue and this is somehow related to the COVID pandemic. But first of all, about the practical side that we operate, we also joined the grand experiment of home officing, and I think this is one of the most interesting peculiarities of the crisis. The lessons that we have learned from home officing. We have an ongoing discussion in our authority that was it a good thing? Was it a bad thing? Should we have more remote working, or is it still better to keep people in the office for the sake of efficiency? It is an ongoing discussion, and in that sense, it has been a very interesting time. Now, one has to bear in mind that 2 months is the special situation in Estonia lasted for approximately 2 months, and this is not a terribly long time in the world of competition. For example, if one asks that what kind of effect did it have on dawn rates, then I think the statistical probability in case of Estonia and most other European competition authorities is that you're not going to have a dawn rate in that period anyway. So it's hard to speculate if we would have been in the position to weigh whether to do a dawn rate or not, what kind of solution would have we come to, but we didn't, and that goes for maybe many other situations that might have been kind of interesting dilemmas during COVID. We tried to avoid procedures where you have direct physical contact with companies. I think that was the meaning of the whole quarantine, and that seemed to work. We managed to do most of the procedures we needed to do remotely, and there was also the question of what to do with companies that were under investigation that were really hurt very badly during the crisis, whose say whole economic activity stopped. So it is a kind of debatable situation what the country should do with that, what the state should do, because on the other hand you still have the public interest to follow the competition rules. So it was a kind of case-by-case evaluation, and in some cases we were more lenient for a rather limited period of time. But then again, now that the quarantine is over, we are back in business as usual. As I said, we didn't witness too many situations, actually nothing major to speak of, where you can say that this is a competition issue that has somehow stemmed out of the COVID crisis. There was this fear that maybe the supply chains are going to be broken, and then the companies need to have certain cooperation to overcome that. Nothing like that actually happened. The supply lines actually work as they used to work. So nothing much to speak about. There were, for example, some minor things from the financial sector. The banks increased the maximum amount of contactless payments, or the limit, which technically is something that falls under the competition law because it is an agreement among competitors. But then again, it wasn't clear it isn't a bad thing, and there wasn't much deep analysis about it. And also there was a certain cooperation about the payment moratoria, but that stemmed out of some European sector-specific regulation. And all in all, I think the most important message here is that competition law has not stopped because of the virus. The basic rules, the so to say laws of nature according to which the markets work and function, they haven't changed, and that means that also the competition law shouldn't change. Of course, what kind of impacts, on the other hand, it is still a bit difficult to say, because the medical crisis, I'm not sure I can say it is over, but it is receded. But the economic crisis, it is very difficult to predict, but there is a fair chance that it hasn't evolved into its full might yet. So it remains to be seen. Once the economic crisis really is there, what kind of effect does it have? Maybe then we are going to see the situation where we really have this kind of typical situations where competition situations that are related to economic crisis, like some kind of emergency cartels or failing firm mergers, but right now we don't see them. And well, that's pretty much our experience during the past couple of months.
Thank you very much, Johan. Thank you very much all for such thorough responses. If I may just conclude, the main takeaways, at least for me, are the following. The competition authorities in the Baltics are quick to adapt to the changing situations. The business of the competition councils continues as previously. Nothing much has changed. The businesses cannot relax, and they have to observe the competition rules. And what was interesting for me, that in the future it might be expected that more and more distant hearings and distant meetings will be organized, also the businesses, if they decide to work remotely, the competition councils will find the ways to collect information as they need it. And it will be interesting to see how the process of dawn raids will develop in the future, given that businesses might also be working more flexible. So thank you very much for this interesting discussion. And now I give the floor to my colleague, Marika Grunte.
Yes, thank you, Monica. Yes, our next topic is one of the most interesting in competition law and related to cooperation between competitors. Usually we speak more about things which are prohibited, about cartels and possible fines for these prohibited agreements. Maybe less focus is at the daily level on what is allowed between competitors and how to use these legal forms of cooperation and where to find them, which are these legal forms. And yes, there have always been in place certain framework according to which companies can assess whether certain kinds of cooperation are allowed or not. Typically, you will find the block exemption regulations, which define such allowed forms of cooperation. Then, if a certain agreement doesn't fit into this block exemption framework, then companies can use the self-assessment to see whether the agreement benefits consumers and competition, and as Šarūnas already mentioned, such benefiting agreements have always been allowed. And finally, maybe what is new due to COVID situation is this European Commission's temporary framework, which has been issued to facilitate business cooperation during COVID. And in this framework also the Commission points out certain types of cooperation and how the Commission would approach them, including that that the European Commission is ready to be more flexible than usual and also act on the basis of the so-called comfort letter, and also be flexible for consulting businesses. And therefore, in this light, I wanted to ask our colleagues from the competition authorities what is the situation in the Baltic countries. And have you noticed any increase in specific types of cooperation agreements which maybe we have not noticed before? And perhaps have you also noticed some illegal cooperation and then maybe initiated some proceedings on this basis? And yeah, so I would ask kindly to comment one by one, starting with the Lithuanian colleague Šarūnas and then later Jānis and Juhan.
Right. Yes, as I have mentioned already in my first intervention, we did notice some increased cooperation. I'll start with our role in advising the central bank when the central bank pushed an initiative that the commercial banks should, in a coordinated manner, agree to postpone loan repayments for individuals and businesses. And in this regard, we as Competition Authority, we were asked to give our opinion, and we advised the central bank, and we also cooperated with the European Commission. We have also seen some ideas of what could have been anti-competitive cooperation in the market. And we have issued some warning letters, for example, to travel agencies. And we have opened one investigation, which I cannot comment, just to confirm that there is an investigation in relation to suspected anti-competitive collective action of the clubs that constitute Lithuanian Basketball League. So this is a summary from the Lithuanian side.
Thank you. Jānis, what is the situation in Latvia?
Talking more generally, nothing maybe has changed. It was mentioned in previous section of the session about procedures. Our, let's say, assessment framework, how we assess any allowed or forbidden cooperation is the same. Also, I will repeat that only in these cases the framework may add some facts or some different circumstances that arise from this emergency situation that affects the businesses. But in any case, that such forms of cooperation need to be objectively justified by such restrictions. That means it's not general, such restrictions are applied or businesses does not work. That means we are allowed to cooperate. It means it's case-specific analysis and need to be justified. Also in terms how it should be long, such cooperation, I believe that it's of course due to the fact that this cooperation is based on the crisis aspects, emergency restrictions. It shouldn't be longer than such restrictions are applied. Of course, later some consequences may affect the market, and later this agreement could be prolonged, such cooperation. But anyway, in such situations, they need to be carefully reassessed due to the maybe structural changes in the market. Also, actual cooperation forms, which are maybe not per se forbidden, but need to be assessed based on the effect and framework. In these cases, which are started before the crisis, such cooperations, due to the market changes and market structure changes in some markets which were affected seriously by such restrictions and COVID outbreak. For example, in some markets, maybe due to a lot of firms, competitors exiting the market structure may change substantially, and some corporations may, in some situations, fall in the, how to say, need to be reassessed because it may fall in the risky side. It may be forbidden according to competition law, mainly need to be assessed according to market share criteria, but also, as there was mentioned, these lock exemption regulations. These, yes, need to be assessed. Is it automatically exempted due to certain criteria mentioned in block exemption regulations, or it could be according to competition law criteria set that it could be individually assessed based on objective reasons, because it's facilitates economic growth, it makes efficiency gains, and also restrictions supply to the market are substantial and are carefully weighted. That means actual cooperation started during the COVID, and also previous cooperation need to be carefully assessed and are assessed by authority now. Yes, for no time. So talking about sectors, as Sharunas mentioned, we also provided, and previously mentioned, we reacted more fastly during this COVID outbreak on the requests of assessing corporations and also consulting on certain risks and aspect risks which could be in such forms of cooperation, as it was mentioned, cooperation between the banks, because as such cooperation was not forbidden because it was pro-consumer, how to say, benefiting the consumers. But anyway, such cooperations might include information exchange, and we were worried about such risks of information exchange included in such agreement, which may point also to the competition restrictions.
Yeah. Thank you, Jānis, and perhaps we can move on to our Estonian colleague Juhan and ask him to comment also shortly about the situation in Estonia.
Thank you. As I did actually point out in the previous intervention, that we haven't had much situations which you can clearly see that this is a competition issue that is somehow related to the COVID outbreaks. So the whole thing has remained kind of theoretical for us mostly. Like other competition authorities in Europe, we also have committed that in case of such situations, whatever they might be, we do take into account the kind of context and the situation. We do take into account that there is a COVID, and then it might, in certain situations, give rise to more lenient application of competition law. But once again, not having any concrete examples about that, it's a kind of theoretical concept, and it remains to be seen what kind of applications might it have in the future. We did have also, like in other countries, the issue about banks cooperating about the payment moratorium, which we did review alongside with a financial regulator. We found that this is not contrary to the competition law, that they agree upon certain conditions, and moreover, it is something that was provided by, I mean, the format that the banks agree between themselves was provided by some sector-specific regulations by the European Banking Authority. So in a way, legally, it was rather limited possibility for the competition authority to say that, no, this is not something you should move forward with. That was limited in the first place. So, but as the economic crisis might evolve in the future, we might have some more concrete examples that might be interesting to talk about. We have witnessed the increase in new cases and applications during the crisis. We don't keep a very exact statistics about that, but generally you can see that we have more applications, more new cases. But it's interesting that almost none of them are actually related to the crisis. They are just your everyday usual competition problems that we have been dealing with.
Okay, thank you very much. Thank you all for this part. To summarize, at least my feeling is that also as regards cooperation between competitors, nothing drastic has changed in the practice of our authorities. On the other hand, I think this COVID time has learned us to be more flexible and try new forms of being in the business. So I think it at least seems that the authorities are also ready to act a bit differently, including being more open to consultations. And yeah, thank you very much for this part. And now I will give floor to my colleague Eva, and she will talk a bit more about the vertical restrictions, which are important, especially important in these crisis times. Eva?
Thank you, Marika, for introduction. Ladies and gentlemen, indeed, now we move from horizontal relationship between competitors to the vertical relationship, with which under the competition law, we understand a cooperation between companies who are on different levels of supply chain. For example, a distribution contract between a manufacturer and distributor, a supply contract, and other vertical relationship. And the European Competition Network, in its recent joint statement on application of competition law during the corona crisis, paid also attention to the vertical relationship, noting that the existing rules allow manufacturers to set maximum prices for their products, and that could be a useful rule to limit unjustified price increase at the distribution level, for example, in the medical and health sector, where we have seen an increased demand for specific medical equipment and health-related products. And within this context, I would like to ask our distinguished guests to comment whether they have seen more questions to their authorities about the application of the pricing rules in the vertical relationship, because as we know, the existing rules indeed allow the application of recommended and maximum resale prices, however, prohibit the resale price maintenance. But whether this distinction is always clear. And a related question would be whether you have seen any more issues arising within this period regarding other vertical restraints, such as selective distribution rules, exclusive distribution, or most favored nation clauses. And finally, if you could just give a brief comment whether you think that COVID-19 might have an impact on the planned reform of the vertical block exemption regulation, which, as you know, is valid only until 2022, and there have been discussions whether the existing rules are sufficient enough in relation to addressing issues on online platforms and the increased volumes of e-commerce. So please, Mr. Šarūnas Kisarauskas, could you start first, please?
Sure. Yes, to answer to your last question, I do believe that the COVID-19 will have impact on the reform of vertical block exemption regulation. Not going into technicalities, because I don't want to preempt the discussions that will take place, but it will have an effect, if only because the volume of trade was on increase anyway, even before the crisis. But what we have seen during the crisis, at least in Lithuania, I'm sure the same was in many other countries, that a lot of people switched to online shopping, and quite a large portion of those will stay online, if not 100%, at least quite significantly. That means that the online distribution channel will become even more important and quicker than in the absence of COVID-19, which acted as a catalyst, if you want. As to the question whether we have received more questions from businesses regarding online vertical restrictions online, well, we have not waited for these questions. We have prepared guidelines that we issued in the midst of the pandemic, and the guidelines address the issues that may come up for both suppliers and distributors online. We call the guidelines competition law also applies online, and we tried in a very simple way, in very practical terms, to respond to some basic major questions that suppliers or distributors may have when it comes to what restrictions are possible or what restrictions are prohibited in their vertical arrangements. And I hope that will help. And if that draws attention from businesses, and if that raises more questions to us, even better, we'll try to help, because as I said, this distribution channel was going to be more important and is going to be more important, and the pandemic has only increased the speed. Thank you.
Thank you, Šarūnas. Now I give the floor to Mr. Jānis Račko from Latvia.
Okay, thank you. If it relates to this block exemption regulation changes, possible changes, I think it depends what will be I fully agree, it depends on that will be the market structure changes after the COVID. But anyway, should it change general, for example, framework, for example, applying per se prohibition on fixed prices, on minimum prices? No, I think it's not will be changed to my mind. But anyway, it also depends on the discussions with the businesses who will provide information, and there will be public consultation on that. Answering on that, I think it's an open question how it will affect, but generally it somehow will affect. Talking about, of course, not talking about per se restrictions, I think it's clear that it's still forbidden, fixed prices and minimum prices. Talking about these maximum and recommended prices, it should be in any case assessed on the effect framework in certain cases. For example, the maximum prices and recommended prices applied in certain markets. I'm not talking about emergency situation, because maybe exceptional situation, and there is other risks that prices may rise unexpectedly in the next distribution level. But talking generally, that there is certain risks that is posed by such maximum recommended prices. That is coordination risk, that future prices in the next distribution level, in the buyer level, will be between competitors will be close to these maximum prices, or close to recommended prices. And this should be assessed and monitored, and if these certain products are supplied and manufacturer have in certain market high market shares, in these cases it need to be carefully assessed. Talking about the price restrictions, of course it's the price restrictions applied in agreements between different supplier and buyer, between supplier and several buyers, so the retailers who are buying, or wholesalers. But other cases when such prices, maximum prices, are regulated by the legislature, and in some countries it was accepted such regulation of maximum prices due to price gouging risk. Prices could rise unexpectedly. There was signs that they rise previously, and there was risks that due to the demand rise, another factors. There is need and objective reasons to fix prices by the law, regulation, and etc. on certain level. Of course, that poses some risk to the innovation and the possible entrance of competitors. What is the right price level in competitive market to set by the regulator, by the legislature, because it could be the legislature, which are not so familiar with the changing market conditions, are not able to adapt so fastly, may be wrong in setting these maximum prices. But anyway, we are very cautious also about recommended and maximum prices if it covers whole market, all the substantial share of the market, part of the market.
Thank
Yes.
you, Jānis. I'm
Okay,
sorry to
thank you.
interrupt. I'm just very cautious of timing, and so now I would like to ask Mr. Juhan Podrus to comment on the Estonian situation.
Thank you. The very short answer to the question that whether we have had any COVID-related vertical situations, then it's no, we haven't had those. Once again, but as a general comment, I think the meaning that the maximum resale prices were mentioned in the joint statement and as part of the kind of COVID approach of the competition law, I don't think it means that the competition law or the vertical approach has actually changed somehow. It was rather seen as a tool that we all remember that when the crisis broke up and the prices of certain commodities increased, especially the masks that you can wear and so, and I think in many countries there was a sort of a vacuum that what can the country do about it, and what kind of legal measures can you take about it, and the reason companies were encouraged to use maximum resale prices was purely to tackle that kind of issue. Now, fortunately, at least in Estonia, that kind of situation haven't evolved into anything massive. We haven't witnessed a massive set of price increases because of shortage of supplies or something like that. In fact, as a very crude measure of price increases, the inflation, we are now having the lowest inflation in Europe, which is a rather new situation for us, but that somehow indicates that the crisis has not had a kind of inflationary impact on the prices. Other than that, whether the crisis should have any effect on the vertical block exemption or the general way that the vertical competition law is seen, it's hard to say. I agree with Šarūnas that it is quite a fair chance that the online trading is increasing. Well, it obviously has increased, but whether it remains that way after the crisis is over. But the gravity of the online trading vis-a-vis competition law is something that has been evolving, and there is a lot of discussions. I think in case of vertical block exemption, clearly one of the main topics is going to be how are you going to tackle the MFNs. It is for those who are not that familiar with the competition law, this is a kind of agreements where the online platform agrees with the seller that it is not going to sell cheaper on its own website or competing platforms. And then there was recently I should say very controversial conclusion to the so-called booking cases. This is probably going to be a very heated debate about how to tackle that issue, whether we should allow MFNs that they have been allowed recently, or should it be somehow more limited, and maybe some other issues also. But definitely online trading is going to have an impact on the way competition law is going to be seen.
Thank you very much, Juhan. So to summarize, we can see that indeed vertical restraints provide valuable tools how to try addressing price issues with respect to highly demanded products. And we can also predict that COVID-19 and the related increasing use of e-commerce might have an effect on the review and reform of the vertical block exemption regulation. So there will be interesting times to come, and by this we can also conclude a discussion on the effects of the pandemic and start to look forward to the future and move to our second topic, which is on the changes expected in the national competition law enforcement due to European Union demands. So now I give a floor to my colleague Bibe. Welcome.